If you've understated income in 1 year, and that's the only year there's problems in, it's hard for the government to look at that and call that tax fraud. But if there's a 3-year period of like behavior, or worse yet, a 5-year period, which is the criminal statute of limitations for most tax crimes, sometimes 6, let's call it 5. If they can show that same pattern of behavior for 5 years in a row, that looks like willful conduct, not negligence, not anything else. When a taxpayer's state of mind becomes relevant to a tax prosecution, what they were thinking when they took an action, here's what the government can do. The government can present evidence of a taxpayer's later actions to refer back to what their state of mind was at an earlier time. For example, even though there's a 5-year statute of limitations on tax crimes, the government could look back to year 6, 7, 8 to show a pattern of non-compliance in those years to give credence to the state of mind of non-compliance in the years open to the investigation. They're going to show this pattern to get away from any inference that you may have been making mistakes. They're going to show this pattern to give the inference that you're willfully behaving in a manner. Evidence concerning your degree of sophistication as a taxpayer, your level of education, is relevant to determine your willfulness. The idea is, if you're a sophisticated person and you're highly educated, you should have known better than to do what you did. Thus, the government's going to provide evidence at trial that you're a professional, that you're highly educated, for the inference that you knew what you were doing and the inference that what your actions were willful. On the other hand, evidence that a taxpayer is unsophisticated, uneducated, maybe a housewife, that sort of thing, could negate the willfulness element.